VWF solicitors, we take pride in our clients' service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. VWF solicitors, we're here to help you with your legal services when you need us.
Hello, ladies and gentlemen. I would like to say you're welcome to Heritage TV Hanging Out with Vicky. And today, as usual, our legal hour with VWF solicitors. Wherever you are in the world watching us live on Facebook, YouTube, Instagram, I would also like to say good morning, good afternoon, good evening to you all. This program is proudly sponsored by Victor Estates, your property company. They deal in managing of property, selling your property, and also renting your property. So if you need any of their services, please contact them on 0744 861 9711. Eagles Heights International School, your one-stop extra maths tuition center. You can call the reception team on 07732202319 and they will answer your queries. And as you can see, this lovely top is sponsored proudly by Queen Esther. If you want to get something similar like this and other tops, do not hesitate to contact me on 0744 861 9711. 0744 861 9711. She's got different designs and different sizes. So if you are interested, you see how beautiful I'm looking today. It's kind courtesy of her. So if you want to look as dazzling and smashing like I'm looking today, please give me a call and I will get her to contact you and you take it from there. Now, going straight to my guests. As usual, I have Mrs. Lawyer Eunice Champon, who today is going to take us through EU settlement scheme between now to 30th June 2021. You will ask yourself, who is, who can apply under this EU settlement scheme between now to 30th June 2021. And Lawyer Eunice is here to take us through who is, who can apply, and also anybody who wants to send us their questions. This is very, very important. Please send your questions to us via Facebook handles, YouTube, and Instagram, and I'll be able to pass on the questions to Lawyer Eunice. Lawyer Eunice, you're welcome to Hanging Out with Vicky, the Legal Hour.
Thank you, Vicky. Hope you're doing very well.
Yes. How are you?
I'm doing well by God's grace. Yes, it's been a good month so far. Apart from the fact that we are in lockdown, at least we are able to do what we can. I mean, some people are still being furloughed, and then others are still able to go to work. But we thank God that it's not as bad as the previous lockdowns that we've had. So we thank God for that. Yeah.
And so far, how is it like? People trying to get things sorted since a lot has changed since the 31st of December, 2020. I know your offices, they've been so busy, but how are
Mm.
things slowing or is getting busier and busier?
Oh, goodness me. With people making applications, I don't think anybody would say that um, things have completely slowed down because of the lockdown. I think when you have something to do urgently, you always see that there is a need to do it and you make sure that it is done so that at least once it's done, you know that it's over and you've done what you can. I remember somebody asking, "Oh, can I still bring my extended family member?" And unfortunately, I had to tell the person the deadline was on the 31st of December. And they were like, "Oh, but I thought there was an extra extension to this deadline of 31st December." And I said to her, "Unfortunately, for extended family members, the deadline was on the 31st." So you can see that people are still eager to do it, but it's just how quickly they are doing it. And I think this program today will be like a warning sign for a lot of EU nationals and their family members to realize that if they haven't made those applications by the 30th of June, unfortunately, they wouldn't be able to rely on those privileges, or should I say, the fact that they've given them this time period or this grace period to be able to make those applications. And that's what it's termed as. The government have termed it as a grace period. And so, as much as possible, people need to be aware that they have a limited time. And from now up to the 30th of June, they have to make sure that they put in those applications so that they don't, it doesn't cost them, or should I say, it doesn't come as a um, consequence to their actions, because a lot of these things people take it for granted, and then when it's no longer there, they are saying to themselves, "Oh, but I didn't know." So we are trying as much as possible to make people aware. And I've also realized that the government has also put certain systems in place for employers, local authorities, um, centers, local centers where the vulnerable and the elderly go, and vulnerable children go. They've tried to put awareness within communities so that as many people who are eligible to apply under the EU settlement scheme will make those applications, because a lot of people are not still aware, unfortunately. And so we need to raise more awareness so that people are aware, and then they can go on and do those EU settlement scheme applications.
So, Eunice, without wasting much time, who can apply for this EU settlement? And why till 30th, 2021?
Okay. So, in terms of the EU settlement scheme, we are all aware that this is a scheme that the government introduced in 2019 for all EU citizens living in the UK and their family members. And so, it also includes those that have retained their rights. So, if for any reason the EU national, maybe that you were dependent on, passed away, or the person that you were married to, you are now divorced from, and for one or two reasons the EU national may no longer be living in the UK, then you can say that you have retained your right. And those people are also people that are eligible to apply under the scheme. And you have people who may be British citizens, but for one or two reasons they've had to live in other EU member states. And having lived there, they've decided to return, and their family members will be applying for um, residence card, 5 years residence card as a family member of a British citizen. And then you also have people who, for one reason or the other, they have EU children or British citizen children, and those children have been in education for some time or are in education, and for whatever reason the EU national is not able to take care of the child, or if the EU national parent is away and has abandoned the child, then it means the non-EU national is the one taking care of the child, or the British citizen child is being looked after by their parent who may not have the right documentation to be living in the UK, and so they are primary carers of these children and therefore have applied for derivative rights to be able to continue to take care of these children. So all these people are the people that the government are saying you are eligible to apply under the scheme. So yes, EU nationals living in the UK, yes, your family members are eligible to apply. Also, those that have retained their rights, those that come under the same principle, and those that also have derivative rights are all the people that need to apply under the scheme. Because what the government is saying is that, well, we've come out of the EU since the 31st of January 2020. Britain was no longer part of the EU, and therefore the rights that you obtained as part of your free movement within the EU will no longer apply. And so now we've implemented those rights within our immigration rules so that anybody who is here and has lived in this country as an EU national for, let's say, 30 years, 20 years, 10 years, and you know very well that the UK has now become your home, then please make sure you apply under this EU settlement scheme so that by the 30th of June 2021, you do not become an illegal person living in the UK. Because previously, under our regulations 2004-38, they said you have a right. As long as you are an EU national, you can go into another EU national country and reside there for at least 3 months without even working or whatever. So for that 3 month period, you know, okay, I can even live there without showing any form of documentation. And then it also goes on to say that if you then want to continue to reside in that EU member state, or you want to continue to work and remain there, then at least you should be a qualified person. And a qualified person is somebody who is working, or who is self-employed, or who is self-sufficient, or even a student who has comprehensive sickness insurance. So after that initial admission where you are taken in for 3 months, then you have to then show that you're a qualified person. And if you're a qualified person, then you have the right to remain in that member state. And then if you want to continue to remain in that state after a continuous period of 5 years, then of course you would be eligible to then say that because you have lived here continuously as a qualified person, you have that right to permanently reside in the UK or in any member state. And so, because it was a matter of rights rather than you having some form of documentation, a lot of that privilege is no longer available. Even though a lot of the applications that were made beforehand, you have to obtain a biometric card which says you have residence card for 5 years or permanent residence. Within the law, we all knew it was a matter of right and not the documentation that that person was holding. And so now that Brexit has happened, they're saying that right no longer exists. And so you have to be able to make those applications so that by the 30th of June 2021, we know that you are here as an EU national, or you are here as a family member of an EU national, and you have that legal right, that legal status to be able to remain in the UK. And this settlement scheme allows people like that to be able to get some form of status, with either that they have pre-settled status, which is leave to remain, or that they have settled status, which is indefinite leave to remain. And so, in doing so, they are saying that now you have come under our rules, and that means that we recognize you as an immigrant who is living in the UK legally rather than as a matter of right. And so, if, for instance, you've had permanent residence, they're saying don't rely on the fact that you've had permanent residence for so many years. Please do apply under the EU settlement scheme so that we recognize that permanent residence under our immigration rules. And so, in doing so, we will give you that status of somebody who has lived here indefinitely or can continue to live here indefinitely for however long you want to live in the UK. And so it's very important that people recognize that this is not something that is for a few, it's for everyone. It's for everyone who has a residence card for 5 years, anybody who has a permanent residence card, anybody who is now applying as a family member of an EU national and obviously wants to be able to have some sort of residence in the UK. So it's not for some people, it's not for the minority, it is for everybody who is an EU citizen and living in the UK, any person who is a family member of an EU citizen, any person who has retained their right, any person who comes under the same principle, and any person who has obtained a derivative right of residence. So it involves a whole group of people, and I think the whole point is to let people be aware. And so I think from now on, I think the government is going to be informing a lot of should I say, agencies such as employers and local authorities and schools and other agencies where they think that people are not aware, and that they have to raise awareness in those areas so that as many people as possible don't fall foul of that 30th June deadline. Yeah.
What is the duration for such application? How long does it take?
So at first, when it was introduced, it would take a few weeks, and then yes, so it would take just a few weeks, and then you get your decision. So they'll give you a certificate of application, and then they'll give you your decision so that you know that you've been granted pre-settled status or settled status. And as time went by, more and more people started applying. And as of last year, I remember the government was saying they did some statistics, and over 3 million EA nationals had applied. And that was just EA nationals, not even including their family members and the rest of it. And so if over 3 million people have applied, you can imagine what the numbers are looking like even now. And so it has taken them a while to recognize that there are a lot of people applying under this scheme. And I think that because maybe they underestimated the number of people, they might not have the staff capacity to deal with it as quickly as they used to. And so now the duration, which was previously under our immigration EA regulations 2016, was 6 months. And so usually, you know that within a period of 6 months, they should have been able to make an application, make a decision on an application. With this current Appendix EU, there is no duration for which they have to have made a decision. And so it is a constant, should I say, a back and forth thing with you having to call them and chase them to find out how the application is going, and you want to, as much as possible, give them as much evidence as possible so that they can make the decision within the required time. And with these EU applications, usually they would say they're supposed to make a decision within 8 weeks, but it never happen. So you might as well give them that extra 6 months, because a lot of the applications are taking longer than expected. And it's not just a minority, it's quite a few people that are able to get it within a short space of time. So when you are lucky, or should I say, when you're blessed to have that decision within that short space of time, then it means that you've really made it. But majority of those applications take longer than the few weeks, the 8 weeks that they say it will take. So yes, if for 3 months or for 4 months or 6 months you haven't heard anything, give the resolution team a call or email them, because they are good with their emails. You can email them and say you haven't heard anything, you want to find out what's going on. And sometimes if you call them, I think that that is also a much quicker way of getting some information as in regards to whatever application that you might be making. So yes, there isn't a specific period of time now, but you can chase them up. And if it's taking longer than the 6 months, you can make a complaint or put in a pre-action protocol letter to let them know that they've taken longer than expected. Yeah.
Okay, so, what will be the effect on people who do not apply to this scheme by the 30th of June 2021?
So, as I was saying, this is a scheme that the government has put in place to protect those people who are EU citizens and their family members, and retained rights persons, and also people who've derived their rights from their children, and those that are under the same principle. And what they're saying is, yes, we've come out of the EU, and if you are not able to regularize your stay through our EU settlement scheme, then it will be as if you're an illegal immigrant living in the UK. And you don't want to be termed as illegal, especially if you've had a residence card or you've had permanent residence. It will be insulting for you, especially when you have lived in this country for such a long time, to then be told, well, you no longer have that right to be in the UK, and so you have to leave. That would be the most insulting thing. And I think that a lot of people are not aware of how serious this is. And so sometimes we take a lot of things for granted, but I think we should not be taking this for granted, because someone I heard someone say to me, well, when the Conservatives had their conference, they said Brexit means Brexit. And therefore, if Brexit means Brexit, then it means that everything else that comes after Brexit is an aftermath of what Brexit has brought about. And one of the reasons why they wanted Brexit was to reduce immigration numbers. And so, as much as possible, if you don't want to be in this hostile and harsh environment that they've created for immigrants, then as much as possible, just do what you're supposed to do by having your stay regularized under the EU settlement scheme. And so they're making it open to employers, to schools, to local authorities, and to different agencies and avenues where they think that those people will be told, or they'll be made aware that this is something that you have to take seriously, and this is something that can later on affect you, because employers, for instance, would not want to put you on any shifts if they don't see, for instance, they will tell you, oh, we want to see that you now have this EU settlement scheme. And the Home Office is always quick to give guidance to employers, to give guidance to banks, and to give guidance to all these other agencies where they think that people should be aware. And so if you are not aware, then please, 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 this is the time to make those EU settlement scheme applications, because you don't want to fall foul and then your employer will tell you you don't have the right documentation, or some estate agents will tell you you don't have the right documentation to be renting a property. You don't want all of those aftermath, those consequences. So, as much as possible, I think that people need to be aware that this is something that they also need to take seriously so that it doesn't affect them in their jobs, in their going to look for a property, for instance, or even with their banks and all the rest of it. So, as much as possible, I think that the awareness needs to be there so that people are aware that this is a scheme that they have to apply under before the 30th of June 2021.
Ladies and gentlemen, if you just joined us, this is Hanging Out with Vicky on Heritage TV, and our guest, as usual, is lawyer Eunice Achampon from BWF Solicitors. And today we've been discussing EU settlement scheme, and between now to the 30th of June 2021. She's taken us through, who qualifies and how to go about, applying for this scheme. And as we always keep, hammering on, we've always been coming out, please, 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 when you are given a deadline to your status sorted, you don't wait till it's, the time is, you say you didn't know. That shouldn't be an excuse. So I will endeavor each and every, if you've got relatives, you've got friends, you've got loved ones, and they fall into this category, please, 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 make sure you put all those necessary measures in place. Deadline is 30th June this year, 2021. We are in January, and you've got how many months more? About 5 months more to the deadline, which is in time for you to have things sorted out. So we don't want to hear stories or people sending messages that, Vicky, I didn't know. So what do I do now? Don't put yourself in that uncomfortable situations. I will also ask each and every one of you, if you have any questions, please let it, send it to me via all our social media handles. We are on Facebook Live, YouTube. You can just send me all your questions. I know this is a very hot topic, and we've got so many people in this situation that need guidance. So please feel free. These questions you would have to, an appointment to see a solicitor to discuss what your options are. You will need to pay a consultation fee. Here on this program, just feel free, lawyer Eunice will be able to advise you accordingly. If it is something that you need to go and see her in the office, we will also get you, in contact with her to take things further from there. But for now, just to have an idea whether you've got everything in place and you fall into that category as well. So please send me all your messages, and I'll be able to ask Lawyer Eunice live on this program. And I would also, yes, I think the questions have started. Yes, Lawyer Eunice, I've got this question that's just come in. I was granted permanent residence 5 years ago and was told the EU settlement scheme is not applicable to me. Is that true or not?
So, in a situation like this, a lot of people have been told, well, you have settled status or you have permanent residence. This EU settlement scheme is not for you. That is not true. That is false. And I think that a lot of people have been sending out the wrong messages to people. And unfortunately, if you've not applied to the EU settlement scheme, even if you have permanent residence in the UK, you will be seen as an illegal immigrant after the 30th of June 2021. And I think that for some people, if they have already applied for British citizenship, or as we would call it, if they have naturalized, then it means that it is possible for them not to apply under the scheme because they are now British. And so, because they are now British, it wouldn't be necessary to apply under the EU settlement scheme. But if you have got your let's say your biometric card, which tells you that you have permanent residence, or you have a passport with a vignette in it that tells you have permanent residence, and you're a family member, or you are an EA national yourself, or you've retained your right, and you haven't applied under this EU settlement scheme, then you are digging a grave for yourself. So you might as well take the opportunity now to go online, look for the EU settlement scheme, and make the application regardless of how long you've had your permanent residence for. Apart from those that have applied for citizenship, everybody else who is an EU citizen or a family member or has retained their rights or derived their rights from their children or under descent still has to apply for the pre-settled status or settled status. And so somebody who is in this category will be applying for settled status or indefinite leave to remain in the UK as of whenever they make their application. And for children, if they also have this permanent residence card, they also have to apply under the scheme. So it's not just for adults, it's also for the children as well. It's for every dependent who has derived their rights from that EA national. And so, regardless of the fact that maybe the adults have made an application to apply under the scheme, those children as well need to make those applications individually under the EU settlement scheme. So it's important that you make the application and then you are aware that you've been granted the settled status or you've been granted indefinite leave to remain in the UK as a family member or as a person who has resided in the UK for over 5-year period. And if you look at our Appendix EU rule, EU 11 tells you exactly that if somebody is a family member of an EA citizen or is an EA citizen themselves and they meet certain conditions, then they will be able to be granted indefinite leave to remain in the UK. And one of those conditions is the fact that they hold a permanent residence card or they hold permanent residence in the UK. So if they have that evidence that they hold permanent residence, those people are also eligible to apply under our Appendix EU. So it's important that the person also makes that application under the EU settlement scheme.
Yes, also sent a question. She says we are looking beautiful. Thank you. I was granted derivative right as the primary carer of my son, 2 years of age. Do I apply now or wait till 5 years is up before I apply under the EU settlement scheme?
Okay, so this is a parent who is saying that, well, she's made that application and now she's thinking to herself, she only got it 2 years ago. She wants to find out, is it possible that I make the application now? Because as we all know, after a continuous period of 5 years, then you're eligible to apply for indefinite leave or previously, as they called it, permanent residence in the UK. For this person, we know that our deadline is the 30th of June 2021. So please, if you have the opportunity now, make use of it. So even if you were granted it 1 year ago, even if you were granted it 2 years ago and it was not under the EU settlement scheme where they were granting leave to remain before, you have to make the application under the EU settlement scheme. You have people who have previously applied under the old rules and they've been granted biometric cards, for instance, that is ending on the 30th of June. All those people will have to apply under the EU settlement scheme. So it's important that as much as possible, this person, whether it's a mother or a father, I'm not sure, but they have to make the application before the 30th of June 2021 for the pre-settled status. So they will grant them pre-settled status, which is leave to remain. And then after she's accumulated the 5 years period, then she can then again apply onto the same scheme. So if she makes the application now and she is granted pre-settled status, at any point in time when she's accumulated the 5 years, she can make the application in the future as well. But it's important that she makes the application now for pre-settled status before the 30th of June 2021. Very, very important, so that people know that even if they are yet to meet the 5 years requirement, they still need to make those applications for the pre-settled status now, so that they are not made foul, or they don't say that they are illegal by the 30th of June 2021. So it's important that she makes the application now before the 5 years is up.
My sister is an EEA national who lives in. I applied as her family member about 3 years ago. At first, my application evidence, no, sorry, my application was refused due to insufficient evidence. I reapplied and was granted 5 years residence card in July 2019. Do I have to apply under the EU settlement scheme?
Okay, so this is a person who is, should I say, what we would previously have termed as an extended family member. So, under our new Appendix EU, you have the definition of who a family member is, and that includes a spouse, a child, a parent, a grandparent. It also includes a dependent relative. And so, for a dependent relative, if they were previously somebody who was granted a residence card or family permit under our previous immigration regulation 2016, then that person automatically becomes a family member, and that's what they term as a dependent relative. So in this person's case, because she now has residence card as a family member of that EA national, she will then be able to apply under this EU settlement scheme as a dependent relative of her sister. So no longer will she be seen as an extended family member as previously we would have seen in our immigration EA regulations 2016, because she now has a documentation to say that she was recognized as a family member. Now she can make the application saying that she's a dependent relative and she has lived here for a period of 3 years, and therefore she wants to make the application under our Appendix EU. This will be under our rule EU 14, to say that she now wants to make application for limited leave to remain as the dependent relative of an EA national, and they will grant her that pre-settled status or limited leave to remain. If the card is still valid, they will not bring you a new card. So I think that's another thing that people need to recognize. Once they bring you that email confirmation that you now have been given pre-settled status, or you've been given limited leave to remain, if you have a biometric card which is still valid, they will not bring you a new one. So the AUSS card, if you for any reason think that you no longer want the card that you have now and you want to replace it with the EU settlement scheme biometric card, that can also be done. So it is a replacement card that can be applied for, and you will be given a new card which shows that you've applied under the EU settlement scheme.
Um, Wonderful. Eunice, can one apply EU settlement scheme for their children in absentia as their EU passport and birth certificate are with parents in UK?
Okay, so for instance, if your child's passport has for some reason been misplaced, or for any reason whatsoever you think that you can't get the passport before making the application, usually they would ask for an identification. If there isn't any identification, then they will ask for a reason why you haven't got any identification. Because most of the applications, including those under Appendix EU, if you look at our EU3, for instance, it will say that you to make a valid application, you will need a valid passport. You will need to also make the right application, and you need to have the right biometrics. So these are the three essential things to make a valid application. And so in asking that, they will say, well, why are you not able to provide the passport? If it's not because maybe the embassy maybe has shut down for one or two reasons, and so it's impossible. Or for instance, I remember there was a time where in our embassy, the Ghana government could not produce the passport, the biometric passports, and so everybody was just given an automatic 1 year extension in their passports. And so if you have an excuse like that, obviously it has nothing to do with you and everything to do with your government. And so you should have a very valid reason why you are unable to produce a passport. Otherwise, you will need a passport for any application whatsoever you will be making.
Um, yes. Yeah, who said I'm married to a Dutch national and we have both applied to the EU settlement scheme. My mother has been taking care of children back home, and I would want all three of them to join me in the UK. Would I be applying for EU family permit or EUSS family permit?
Okay, so in this case, the person is trying to make an application for their children and mother to come into the UK. And also, that's a good thing because at least they'll be able to have the close knit family they've always wanted here in the UK. And when it comes to EU family applications, so those applications made for family permits, if you look at our Appendix EU, it states who close family members are. And so if you are looking at who the close family members are, like I said previously, that includes those in the ascending line. So your parent, your wife, your child, your grandchild, and then obviously, if that person was already recognized as a family member, then that dependent relative will also be a close family member. In this situation, they want to bring their children and their parent. And we should also be aware that the deadline is the 30th of June 2021 to make those applications for family permits. So, in making that application, they would also need to make sure that they applied under the EU settlement scheme themselves. So, usually, if the EA national, including the non EA national, have applied under the EU settlement scheme, they will be granted pre settled status or settled status. And if they have been granted pre settled status or settled status, when they are making the application for the children and the parents to be granted family permits for 6 months, they are going to be putting on the application that they have themselves applied under the EU settlement scheme, and they are now making the application for that parent or for the children to join them under the EU settlement scheme. And one good thing about the EU settlement scheme is that if you're a child under the age of 21, whatever your parent has been granted, they can grant you the same. So if they are given that family permit for 6 months, when they come into the UK and they apply under the EU settlement scheme, that child will also be given indefinite leave if the parent has indefinite leave, or they will be given pre-settled status if the parent has pre-settled or limited leave to remain in the UK. For the mother as well, they would obviously have to make the application for family permit for to be given that 6 months leave to come into the UK. Once they come into the UK, they will have to make their application to show that they are dependent on their child and their child is looking after them. Their child is supporting them financially. Their child is also supporting them in terms of their essential needs. So if the mother is living with them as a family unit, then obviously she will have some evidence to show that she's living with them, and um, that son or daughter is making transfers into their accounts as and when they need the money to be given to them. It is important they show that indeed their parent is dependent on them, and it's also essential that at least they are able to show that indeed their mother is dependent on them for her financial needs. And so when it comes to EA family permit was how we termed all the family permits under our immigration EA regulation 2016. So formally, where we didn't have the Appendix EU and we didn't have the EU settlement scheme, we always termed family permits as EA family permits, and that was the former name for those applications that were previously made. So now it is essential that anybody who wants to apply for any family member to join them have themselves made the application under the EU settlement scheme so that they can then apply for their family member to join them under the EU SS family permit.
I was just wondering, what if someone is a citizen of a EU country
Mm.
and have lived in the UK, but previously left? Can
Mhm.
that person still apply under the settled status using those years that he's been in this country? Or does he have to continuously live here for 5 years? I just thought
Okay,
about
so
that question.
yes, so if that person was an EU national and they previously lived in the UK, and let's say they've been away, so under our previous EEA immigration regulations 2016, you could have, for instance, let's say permanent residence, and if you were away for a period of 2 years, that automatically would cancel out your permanent residence because you were away for a period of 2 years. If you haven't acquired permanent residence whilst you were in the UK, so let's say that you were previously living in the UK and then you went back to your country of origin, under our Appendix EU, to be able to eventually make an application for permanent residence, or now we call it indefinite leave to remain, you should be able to show that you were living here continuously and you shouldn't have had 6 months absence in each given year. So if, for instance, that person has now moved to their country of origin and they did not accumulate a 5 year continuous period, and let's say now um they've they've been away for, let's say, a year or a year and a half, and they only lived in the UK for 3 years. And so, having lived in the UK for 3 years, they moved back to their country of origin, and they are now thinking, oh my goodness, I really did not think that this will affect me in any way. If they were granted residence card or they were granted registration certificate, the registration certificate is the blue card that they give to EU nationals. So if they were granted a blue card, then that means that they have a document which evidences the fact that they were granted residence card. But in terms of living here, as much as possible, they should still have some sort of evidence to show that they are living here or they were previously living here. And if for any reason they can't evidence that before the 31st of December they were living in the UK, then unfortunately that will become difficult. Because as I was saying, in hindsight, if you're going to make the application for permanent residence and you are not able to show that you've lived there continuously, not being absent for a 6 months period, then it makes it very, very difficult for you to then make an application for permanent residence. So I think that is important that that person had come into the UK before the 31st of December so that they can show that, oh, at least I was here, but I am now sort of starting all over again. So the previous years that they had lived here will almost be like years that have gone by, but they are now starting again because you don't want to be making an application where you know you wouldn't meet the continuous residence of 5 year requirement. So now, if they are able to show they were in the UK before the 31st of December 2020, then they can make, and I mean, they can obviously make the application for pre-settled status or limited leave to remain so that they can continue living in the UK.
Is up. I hope we were able to do justice to the topic, looking at the questions that came in. All the other questions that are, still coming in, I will pass it on to Lawyer Eunice. I beg your pardon. I'll pass it on to Eunice and I'll make sure she contacts you, and we'll take it from there. Eunice, any other information you have for us? And also give us your details for those who would like to contact you for advice.
Okay, so Vicky, as we've said today, this EU settlement scheme, as we are making people aware, has a deadline for the 30th of June 2021. So those in the UK should apply by this date, and those who want to bring close family members outside of the UK as well should be making those applications by the 30th of June 2021. It is important that anybody who wants to make the pre-settled status application or the settled status application in the UK should be making those applications by the 30th of June 2021. It will only be in very exceptional circumstances that the government will allow somebody to make the application after that date of 30th June 2021. They haven't come up with a policy yet as to what will be a reasonable reason for not making the application yet, but the message being sent out by the government is you need to make those applications by the 30th of June before any other consequences come from that. So if you are an EU citizen living in the UK, or you are a family member of an EU citizen, or you've retained your rights, or you come under the sharing the same principle, or you've even derived your right from your child who is either an EU national or a British citizen, that it is important that you make these applications under the EU settlement scheme. And it is also important that you also make those applications for your family members to join you by the 30th of June 2021. Once that deadline is gone, any other applications for any family members to join you will be applications done under our immigration rules. It would not be as easy as you have it now. Um, I think that was one of the reasons why people wanted us to leave, because they knew the EU free movement gave people an easier route to come into the UK, unlike our British immigration rules. So, as much as possible, let's heed to this deadline and let's make those important applications as soon as possible. As Vicky said, I am Eunice from BWS Solicitors, and our offices are situated in Seven Sisters. So our address is the fourth floor of Anna House. So BWS Solicitors, fourth floor of Anna House, 214 to 218 Tottenham High Road. The area is London, and the postcode is N15 4NP. So N15 4NP. And our offices are open from 9:30 to 6 p.m. And our office telephone number is 0208 493 7340. So 0208 493 7340. We are open from Monday to Fridays. And if you want to contact us out of office hours, you can contact me directly on 075 35 81 3910. So 075 35 81 3910. Thank you so much, Vicky.
So yeah, Eunice, I think today around 4 o'clock, you guys will be coming. BWF solicitors will be coming on live on Facebook, and the community and law. All right.
Then, yes.
Yes.
So every Saturday, yes. Every Saturday from 4 to 6 p.m., we have the community and the law, and we discuss any topic that we think is prevalent in the
Okay. So on that note, we've come to the end of the program. I'd like to say a very, very, very big thank you to all of you who, stayed with us throughout the program. Those who shared, those who sent their messages. Thank you so much. We appreciate you. We adore you. Please join us again, same time next week with our legal hour with BWS Solicitors on Heritage TV. Take care of yourself and stay safe.
BWF Solicitors, we take pride in our clients' service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.